Uh, Hello, class. This is Demetrius Wilson with Business Law. We are now on Chapter 9, Contracts. Again, another chapter on contracts. Capacity, legality, assent, and form are the different topics we'll be discussing, or the main topics. Our learning objectives for the chapter. Does a minor have the capacity to enter into an enforceable contract? What does it mean to disaffirm a contract? So a lot of the chapter will be on, whether people have the capacity to enter into a contract, whether it be a minor or whether it be competent mentally or not mentally ill. What is an exculpatory clause, and in what circumstances might exculpatory clauses be enforced, and when will they not be enforced? We'll learn about in what types of situations a voluntary consent to a contract's terms may be lacking. We'll also discuss what are the elements of fraudulent misrepresentation, happens all the time, and what contracts must be in writing to be enforceable, like sale of land that needs to be in actual writing. So contractual capacity, the legal ability to enter into a contractual relationship, right? If someone's not competent or sane, then they probably don't have the legal ability to enter into a contractual relationship. Minors, in most states, a person is no longer a minor for contractual purposes at the age of 18. Can't drink alcohol, but for contracts, you can sign a contract, you can go to war, but no alcohol. A minor can enter into a contract that any adult can, and that's actually true. But a contract entered into by a minor is voidable at the option of that minor, so they kind of have an option to get out at any time that they want. And that's typically why, merchants and people don't want to get into contracts with minors. But then we'll talk about if somebody misrepresents their age a little bit later. A disaffirmance is a contract can be disaffirmed at any time during minority, meaning when they're a minor, or for a reasonable period after the minor comes of age. So just after you turn 18, but not when you're 20. Minor must disaffirm the entire contract, not just portions of the contract. I don't like this portion of the contract, so I'm going to keep it. And I want to do away with these other parts. No, you have to disaffirm the entire contract. A disaffirmance can be expressed or it can be implied. In last chapter, we talked about how things can be expressed and also how they can be implied. Remember, I talked about setting the box of your tax records down and then leaving and coming back. And obviously, you implied that somebody was going to do your taxes. Minors' obligation on disaffirmance. So in most states, minors need only to return the goods. So they just need to bought the computer, bring the computer back, have to give them their money back. Subject to the contract, provided the goods are in a minor's possession or control, right? So if you took it, bought the computer, then you gave it to somebody else and now it's gone, you're not going to get your money back in that instance. An increasing number of states, the minor must restore the adult to the position held before the contract was made. Well, what position are they in before the contract was made? The position that they were in is that they had a computer or a laptop. And the position that you as a minor were in was that you had money in your pocket. So as long as both sides are returned back to that point, then they're good to go. Exception to minor's right to disaffirm. So misrepresentation of age. Generally, minor can disaffirm the contract. But growing number of states prohibit disaffirmance and hold the minor liable, meaning you lied about your age, we're going to hold you liable because you lied. Contracts for necessaries, right? What are necessaries? Things like food, shelter, clothing. Contracts for food, clothing, shelter may be disaffirmed by a minor who remains liable for the reasonable value of those goods, right? So you can disaffirm the contract, but you remain liable for those goods. And you don't want to take those things away because those are things that you need to live and survive. Insurance is not viewed as a necessary, even though it is really necessary that you have insurance. So minors can disaffirm contract and recover all premiums paid. Loans, they're seldom considered to be necessaries, except for, and the exception is when a loan to the minor is for the purpose of purchasing necessaries. You see it all draws and ties back to necessaries. A ratification occurs when a minor or on after reaching majority indicates expressly or impliedly an intention to become bound by a contract made as a minor. So meaning, hey, I got another contract as a minor, 16. Now I'm 18. I want to ratify and say, hey, yes, I want to continue with this contract and keep it going moving forward. Executed versus executory contracts, parents' liability. So now, there are a couple cases here that I want you guys to review in terms of how liable is the parent when these minors enter into contracts. Parents not liable. This is why parents are usually required to sign any contract made with the minor, right? Because, people have been down this road and they've been sued before and they know, like, hey, we need you to sign too. Torts, minors are personally liable for their own torts. Liability imposed on parents only for willful acts of their minor children, and liability imposed on parents for their children negligent acts that result from their parents' negligence. So if the parent's negligent and the kid ends up involving themselves in negligent act, yes, the parent will be they will be liable as well. Intoxicated person. So a lot of times when you're dealing with intoxication, it depends on how intoxicated. And then, that's for the judge and jury to decide. Lack of contractual capacity at the time the contract is being made. The contract can be either voidable or valid, right? So remember, it can be voidable because they're too drunk, or valid because although we were having cocktails, I was still in my right and sane mind when I signed the contract. Courts look at objective indications to determine if the contract is actually voidable. If voidable, a person has the option to disaffirm, or the person may ratify the contract expressly or impliedly and say, hey, you know what? Yeah, I was drinking, but I'm okay with the contract. Mentally incompetent persons. So it's going to be void if a person has been adjudged mentally incompetent by a court of law and a guardian has been appointed, right? And there'll be, significant paperwork on that. So it's pretty cut and dry. It's voidable if the person does not know he or she is entering into a contract or lacks mental capacity to comprehend its nature, purpose, and consequences, and they want to get out of it. It is valid if the person is able to understand the nature and effect of entering into a contract, yet they lack the capacity to engage in other activities. And that happens sometimes. You see people, certain sides of the brain don't work, but other sides of the brain work quite well. Legality. So a contract to do something prohibited by federal or state statutory law is illegal and therefore void. It never existed, right? So you can't contract with me, give me $10,000 to go rob somebody because it's against the law. Then I come try and sue you and say, you know what, I robbed him and, he never gave me the $10,000. Obviously that contract is void. Contracts contrary to statute. Contracts to commit a crime. Obviously, we just talked about usury. So that's like a crazy, insane interest rate, right? So, you're going to let me borrow some money and you're going to charge me 50% interest rate, right? That's usury. Gambling and licensing statutes. Contracts and restraint of trade. So covenants not to compete. If you haven't run into this, I'll give you guys a good real world example. And the sale of an ongoing business. So covenants not to compete in employment contracts are legal as long as the duration and geographic limits are reasonable, right? And so in the case that I'm going to show you, it's not reasonable, but let me give you a reasonable example. So one person works for copier company A, and then he leaves and goes to copy company B, copier company B. Copy company A says you have to sign this covenant not to compete because we know that you have that secret list of all your clients that go with you, whether you're a copier company A, B, or C, they're always going to go with you. So we know, so we want you to sign that. They'll probably give them a little bit more money. And I've actually seen it where a guy, no joke, he came in for 2 years. He set his desk. He read the newspaper, played tic-tac-toe, and some other games and everything, played solitaire, and then he left for the day. Until 2 years after that, he cracked open that list and he made all those calls and made all of those sales. And that's what company B was just waiting on because they knew he had all these sales. Company A was like, hey, let's get our pipeline going so that we can backfill and make sure that we have sales to cover these sales that he's going to take away. In this one, case of Comedy Club Inc. versus Improv West Associates in 2009, the covenant was not to compete for 14 years, covering 48 states. That's too broad and therefore invalid. Like, you can't say, hey, well, I have a covenant to compete for forever in any state, right? It doesn't make any sense. Unconscionable contracts, procedural unconscionability or adhesion contracts. So, the entering the things that, are really, really unfair. Substantive unconscionability means when terms of a contract are oppressive or overly harsh, right? Like you have to wash my car for every day for the next 15 years. I mean, obviously, that's something that, will be thrown as a very unconscionable contract. So it's interesting when you look at, gotta love pictures, diagrams, and see how it flows down the left and the right side. So in a unconscionable contractor clause, there's a contractor clause that is void for the reasons of public policy. So if we look down the left side first, right here, you have procedural unconscionability. This occurs if the contract is entered into or the term becomes a part of the contract because of the party's lack of knowledge. And underline that in your brain, lack of knowledge or understanding of the contract or its term, right? So the lack of knowledge is the key thing, and the judge will quickly see that. The factors that the court actually considers is the print inconspicuous, right? It's like, oh, it's hidden down here in 1.2 font. Is the language unintelligible, right? Do I not understand it because I'm a layman and I don't know about the particular industry? Did one party lack an opportunity to ask questions about the contract? That's quite possible. And was there disparity or bargaining power between the parties? Like, hey, you know what? Take it or leave it. I know that you need this car. And so I'm going to make an unconscionable contract, and you have to take it because you really need the car. Now over here on the right side, substantive unconscionability. This exists when a contract or one of its terms is oppressive or overly harsh. Factors that the court considers: does the provision deprive one party of the benefits of the agreement, right? So somebody in the agreement deprived. And does the provision leave one party without a remedy or for non-performance by another, right? So it's basically just saying, is it unfair? Exculpatory causes release a party from liability in the event of monetary or physical injury, no matter who is at fault. Court typically tries to stay away from that because they view these causes with a general disfavor. Effective illegality. Justifiable ignorance of the facts, right? So, it's like, oh, okay, well, there's justifiable ignorance of facts, and then there's just straight out, I just ignored facts that I could have learned about and understood. Members of protected classes, withdrawal from a legal agreement, right? Remember, illegal, that it's an agreement, but it's obviously void because it's not something that you can do. Severable or divisible contracts. And a contract illegal through fraud, duress, or undue influence. In the next few slides, we're going to go over that. Like fraud, I'm representing myself as somebody with a fiduciary responsibility to handle your finances, and I'm really taking your money and going to the Bahamas. Duress, somebody has a gun to somebody else's head and they make them sign a contract. And undue influence, somebody's an expert and they have a lot of influence over the situation. You're just listening to what they're saying because they have expertise, but you don't. And that ends up, being undue influence in terms of your decision. So voluntary consent mistake. So material mistake of fact. So you have a bilateral mistake. So remember, bi means two. So both parties are mistaken. Contract can be rescinded by either party, right? So both of us made a mistake. I put down $500. You put down $5,000. It was supposed to be $50. You both made a mistake. Either one of us can rescind it. A unilateral mistake. One party is mistaken. So the contract is enforceable unless the other party knew or should have known that the mistake was made, or the mistake was due to substantial mathematical error, like I talked about the 500 and 5,000, made inadvertently and without gross negligence, right? It's just, I just, fat fingered an extra number in, it happens. Or like, it's funny, I was watching, with the kids, I was watching Sing, and the old lizard, she just, put in the number and then she got distracted and her fake eye rolled out and she accidentally put in a couple extra zeros. So it was supposed to be, I think it was $100. It ended up being $100,000. So you have to understand, like, when those type of mistakes are made. If you could justify it, then they're usually let off the hook. Just general mistakes, mistake of value or quality, contract is enforceable. Unilateral mistakes of fact, party does not have the right to cancel the contract unless the non-mistaken party knew or should have known, or there's a clear clerical error, and that's just like the slide that we just saw. Bilateral mutual mistakes, right? Mutual, two of us, we agree, we both made a mistake, or just by fact we made a mistake. If both are mistaken, either one can cancel the contract. Like in case 9.2, once you check that one out, Inkle versus Pride Chevrolet Pontiac. For mutual mistakes to occur, both parties must have been mistaken about a material fact, and this was a matter of fact for a jury. So check that one out. Always quite interesting, the cases that they add to the text. A fraudulent misrepresentation. So a contract is voidable by innocent party. Injured party must show the following: misrepresentation of material fact. And when you say material fact, usually followed by that is not an opinion. By conduct of law, silence, or words. Like again, opinion is not a fact unless it's an expert opinion, like you see on Dateline and First 48 and all those things. You see, oh, here's a blood spatter expert, and these are people who have been in the field. But find it interesting that a lot of people are saying now, like, these people aren't really experts, and they're experts to a certain extent, but they can't really replicate things that really happen, and they're just giving a best guesstimate. Case 9.3, Rosenzweig versus Gibbons. So whether fraud was committed in the context of a fiduciary relationship between the parties was a question of fact for the jury. So check that one out. That's always interesting when you're dealing with somebody's money and people, they feel, I don't know why, they end up feeling privileged and they feel like, well, this person should be paying me more. I'm just going to go use and take and spend their millions of dollars like they really own it or deserve it. Also in fraudulent misrepresentation, so an injured party must show intent to deceive, right? So if there's intent to deceive, you have to show that. Innocent party must have justifiably relied on the misrepresentation. So I relied on this car to get to work, and now there was no engine in the car that you sold me. And the plaintiff must have suffered legal injury. Undue influence and duress. Obviously nobody wants to be in these different scenarios. But undue influence arises from a special relationship of trust. A stronger party overcomes a weaker party's free will by exerting psychological influence, right? Maybe a little bit, more of a veteran in the game, and they exert that psychological influence. Duress is a threat of physical force or extortion. Can serve as a basis for rescission of contract. Economic need by itself is not duress, right? So duress is, like I said, somebody's got a knife or a gun up to somebody's neck or head, and then they're signing a contract under duress. So business contracts that must be in writing to be enforceable. We talked about this as one of the learning objectives at the very beginning of the lecture. Contracts for the sale of goods priced at $500 or more. Contracts involving interest in land. Contracts that cannot be performed within 1 year. And contracts containing collateral promises. And down here that you can read on your own are the exceptions. And there are always exceptions to the rule. Statute of frauds, writing requirement, requires certain contracts to be in writing and signed to be enforceable. Just like we talked about, if you want to buy a piece of land, you're going to have to sign some documents. Interest in land, a contract involving an interest in land, including sales, fixtures, leases, mortgages, and easements. The 1 year rule is in effect. A contract that by its terms cannot be performed within 1 year of execution, right? So if it can't be performed with 1 year execution, then it falls in that boat as well. So here's a 1 year rule. Like I said, pictures are always great. So you have the date of the contract formation. You slide down to the right, 1 year from the day or date of contract formation. But down here, if the contract can possibly be performed within a year, the contract does not have to be in writing to be enforceable. But if it's beyond that year, if a performance cannot possibly be completed within a year, the contract must be in writing to be enforceable. Statute of frauds, collateral promises, answer for the debt of another, right? Like when you co-sign for somebody. Contracts, which is not a great idea. Contracts with primary and secondary obligations. Only secondary obligations must be in writing. Exception is the main purpose rule. So the guarantor seeks to secure personal benefits. So then a lot of times some of these people don't have great credit. They're going to run out. They're going to do all this and that. We need somebody responsible to pay the rest of this. Promises made under consideration of marriage. So unilateral promise for money or property must actually be in writing. Contracts for the sale of goods over $500 must be in writing. Otherwise you can, go hash it out in, small claims or people's court. Exceptions, partial performance, detrimental reliance, right? So partial performance, I'm paying half of your house, detrimental reliance, you're relying on, the sale of whatever goods. Statute of frauds and exceptions. So exceptions to the statute of frauds. So admissions by party against whom enforcement is sought, and a promissory estoppel or detrimental reliance, which we just spoke of. A special Uniform Commercial Code exception. So oral contracts for sale of customized goods may be enforced, right? You know that person made customized good, such as some fancy stained table specific to your house that matches the paint and everything, right? That's customized goods, and it will be enforced. And oral contracts between merchants may be enforced as well. Statute of fraud, sufficiently of the writing. Or sufficiency of the writing. So what constitutes a writing, as they say? So it's a written contract or contracts or memorandums, paper or electronic, signed, and that's the key point. You see how it's all in caps, signed by the party against whom enforcement is sought, typically the defendant in a case. Documents can be incorporated into each other. So what must be contained in the writing is the big question. So essential terms only, must name the actual parties, and it has to be signed by the party against whom the enforcement is sought, usually and typically the defendant. Providing an e-signature is a matter for trial. A lot of times, we're in a new technology age. E-signature, people, writing on a screen or an iPad, that should fly. And that's it for Chapter 9. So I want you guys to make sure that you complete everything that's on the docket for this week, whether it be a quiz and or possible tests and or assignments, everything like that. But if you have any questions, be sure to email me. I'm always here to help. But as always, I want you all to have a good day and a great week.